Name is Rita, middle initial A. Nesbitt. I want to tell you a story about 160 acres that my husband and I bought in Colorado that we bought in 1966. For a while I taught school in the Beulah Valley there, and we really got to know the valley and the people, and just absolutely precious group of people. And the judges end up taking away our easement, taking away our right to use the land at all by blocking us out. The neighbors, named Scott, kept throwing at us and kept us busy responding and paying more and more attorney fees on our side. The miscarriage of justice is that we had to go through all this for over 12 years. We still got nothing to show for it. And they would schedule the hearing, and then my son would drive all the way out there, and then they would cancel it at the last minute. And that happened several times. Now, not only are they not letting us into our property, they're trying to make us pay for what they spent on their attorneys keeping us out, which to me is like, that's all wrong, because they were the ones that brought the suit against us and kept us out and forced us to defend ourselves over and over and over again.
The Scotts asked for an injunction which was granted by a judge that just before a hearing recused himself because he knew the Scotts personally. A new hearing was scheduled with Judge Larry Swartz. Larry Swartz ruled that Rita's easement disappeared upon the death of the woman who reserved that easement, leaving Rita landlocked. Rita exercised her constitutional right to condemn and access to her property. The day before the condemnation hearing, Judge Swartz vacated the hearing and awarded the Scotts legal fees. Immediately after his ruling, he recuses himself from the case. Rita is forced to appeal the erroneous Swartz ruling. The ruling is overturned by the appellate court. The appellate court rules that Rita is entitled to her hearing. The route Rita chose to condemn is a historic mining and logging road that leads directly to her property. This is a picture of the route Rita was using. This is a picture of the route after she was blocked from her property for 10 years. And the case was assigned to Judge Jill Mattoon. Judge Jill Mattoon ruled that Rita had a present enforceable right to build a new road off a cliff, over a public waterway, into a canyon, across over 10 parcels of private property, through a locked gate, and that none of the property owners needed to be joined in this case. Judge Mattoon awarded the Scotts over $500,000 in legal fees for proving an enforceable right to an alternate route, and in her own ruling stated that the 10-plus property owners were not bound by her ruling. Now Rita has a catch-22 in that she has an enforceable right that is not enforceable and owes over $500,000, and her property has no legal access still to this day.
And this is what the court accepted that Rita should have to build a road on without having the people who own this house joined in the court case. So in other words, Rita's supposed to show up with this property in a bulldozer with supposedly the enforceable right to build a road right up there, and these people would have no say about it, which of course is incorrect. And based on the feasibility of this road, the judge awarded the Scotts over $500,000 in legal fees.
Okay, so this is one of the proposed accesses that Rita Nesbitt is supposed to use to get to her property. So, can you imagine building a road straight up this? Rita contacted the 10-plus property owners. They refused to give her access, stating that they knew nothing about the ruling and were not obligated to cooperate.